Hello friends, I'm your friend Advocate Deepak, and today I'm giving you the information about the NDPS Act, some of the power of trial court and some of the important statutory provisions, and also something special which is given by the Supreme Court of India recently in July 2025. So before starting with this video, my request to you, please subscribe my channel and please press the bell icon button. Thank you very much, and let's start this new video. Section 32B of NDPS Act does not restrict trial's power to impose sentence higher than the statutory minimum. This means the Supreme Court on 17th of July clarified that Section 32B, that means the factor to be taken into the account for imposing higher than the minimum punishment of narcotic, drugs and psychotropic substances, Act 1985, that means the NDPS Act, generally does not restrict the trial's power in awarding the sentence higher than the minimum of 10 years. To state briefly, the appellant was convicted along with the another accused, that means the co-accused by the Special Judge NDPS under Section 21C of NDPS Act, for being in possession of 236 vials of various cough syrups containing codeine phosphate, a psychotropic substance. He was sentenced to 12 years of rigorous imprisonment along with the fine of 1 lakh rupees. In appeal, while affirming the conviction, Chhattisgarh High Court reduced the sentence to 10 years. Relying upon Supreme Court's decision in Rafiq Qureshi versus Narcotic Control Bureau, Eastern Zone Unit 2019, the High Court said that at the time of imposing the sentence, the trial court need to keep in mind the aggravating factor as providing in clause A to F of the section 32B respectively. In absence of such factor, it contains impose a higher sentence than prescribed minimum. Against this, appellant through advocate on record approached the Supreme Court of India, arguing that entire seizures was vitiated as same suffered from the serious infirmities. The bench, comprising Justice J.B. Padiwala and Justice R. Mahadevan, however, dismissed the SLP, finding no good reason to interfere with it. But it clarified that the High Court misconstrued Section 32B as restricting the trial court's power in imposing a sentence beyond the minimum in absence of factors listed therein. It said, after an understanding of High Court is not corrected, and Section 32B provides that the court, in addition to various relevant factors, may also take into account the factors as prescribed clauses A to F. Therefore, in given case, the trial court may not find it necessary to consider the factors as prescribed in Section 32B, having regard to quantity of the contraband, the nature of the narcotic or psychotropic substance, as the case may be, the antecedent. It may deem fit to impose punishment which can be more than the minimum. In such circumstances, there was no good reason for the High Court to reduce the sentence from 12 years to 10 years, relying on Rafiq Qureshi. The dictum as laid down in the of Rafiq Qureshi has not been understood in the true perspective. The court added that Rafiq Qureshi, if clarified that the language of Section 32B inherently preserves the court's discretion to consider other relevant factors beyond those listed specifically, the quantity of the narcotic substance was deemed a pertinent factor warranting a sentence higher than the statutory minimum, despite the absence of any enumerated aggravating factor. The case citation was Narayan Das versus State of Chhattisgarh. The verdict on this particular matter was awarded recently in 2025, month July. So this is one of the important information for you. You would like this information. So if you like and you think that some of the information in this video or complete video, then please like this video and subscribe and share also.